SJC-13506, Commonwealth v. Nelson, Barros.
Excuse me. Someone's forgetting a briefcase here.
Thanks.
Thank you.
Okay. Attorney Crane.
Good morning. May it please the court, Edward Crane on behalf of Nelson Barros. The right to counsel is one of the most important constitutional rights in the criminal justice system. The question asked here is, what must a defendant know in order to waive this right? Does the defendant need to know simply that the right exists, or must the defendant understand that waiving the right and representing oneself is a difficult task that carries significant risk? Both this court and the appeals court have repeatedly concluded that in order to validly effectuate a waiver of the right, a judge must advise the defendant about the seriousness of the charges, the magnitude of the undertaking, and the disadvantages of self-representation. The motion judge here distinguished the defendant's situation because he subsequently tendered an admission instead of proceeding to trial. According to the motion judge, less is required to effectuate a valid waiver when the defendant ultimately pleads guilty.
Mr. Crane, as far as what happened here, we see these immigration mistakes being made by lawyers, right, on the pleas to deportable offenses under the Padilla cases, and your client received a quaff for a fairly egregious act. Did pretty well for himself. How do you address the prejudice prong?
Your Honor, I think he would have done that. Would have been a good deal for him if he was a citizen of the United States. But
this seems a lot like the cases we have under Padilla, though, right?
Certainly, and I think that there's an element where the analysis is the same. I think where the prejudice arises is that if he had not invalidly waived the right to counsel, had an attorney, the attorney would have advised him about the danger of taking a quaff and how that could have, that he would be subject to.
I don't understand how explain the value add, because I'm really struggling with the prejudice issue. Because if you're saying that the value add to the attorney would be, you really got to think about this, Mr. Barros, because if you take the plea on this, you're more than likely going to get deported. That's exactly what the court said to Mr. Barros. So what would be the value add of the attorney parroting what the judge said under Rule 12? What would be the value?
Well, I would respectfully disagree that that is the same as what the court advised him at the plea hearing. The 29D warning.
No, it wasn't the 29D warning that I'm speaking of. I'm speaking of the Rule 12 warning, saying that you are more than likely going to be deported if you take this plea. I forget what the exact words, but it's in, you know what they were. He told him exactly what an attorney would have told him. They are going to come for you, and what exactly the court warned before the plea is exactly what happened to Mr. Barros, right?
Correct, but the problem with the Rule 12 warning, and this court has recognized this issue in the Pettit home case, is that it conditions all these dire immigration consequences on certain facts that a defendant can't know without the
Pettit home was a 29D case, wasn't a Rule 12 case, it was a 29D case. So that's what that was. This is the admonition that the court gave to Mr. Barros under Rule 12. And exactly what the court foreshadowed is what happened. The 29D would relate to what happened to Mr. Barros on his way back in, right? He got detained. But the part about what happened subsequently, about that you are more than likely going to be deported, that's under Rule 12, and that's exactly what happened. And what else would a lawyer have said other than that?
Well, I guess the issue with Rule 12, and this is what the court said, I think, in Pettit home, is that it conditions that language about presumptively mandatory removal on if this is a case that, if this is a conviction that presumptively mandates removal under federal immigration law, then it's practically inevitable that you'll be deported. And the issue that the court found with that language in Pettit Home is that it conditions it on this, well, is it a conviction that presumptively mandates removal? That's something a defendant doesn't know.
But in this case, he said it is. This is a charge, right? In this case, the judge says it is. There's no uncertainty about that.
I'm not exactly sure what the, if the judge did use some more different language from Rule 12, I'm not aware of that. I thought that he followed the language that was mandated by Rule 12, but I would reiterate that, that the court has held that Rule 12, that warning is problematic, and it's been done away with. So that's no longer required. And I think there is a distinction too, even if...
You have the Rule 12 warning here in the record? I haven't read the full record yet. Do we know exactly what was said here?
We do.
It's page, where is it?
So I can't give you the exact page of the record, but I can tell you what at the hearing. The judge says, if the offense to which the defendant is pleading guilty, nolo contendere, I'm sorry, pardon me. I was reading, that's the rule itself. If you give me a minute, Justice Caffer, I'll give it to you.
No, I don't mean to distract. Unlike you, I'm not familiar with the terminology.
Here it is. So the judge says to Mr. Barros, if you're not a citizen of the United States, you're hereby advised of the acceptance by this court of your admission of sufficient facts or plea of guilty may have the consequence of deportation and exclusion from the admission to the United States or denial of naturalization pursuant to the laws of the United States. And you would would presumptively mandate removal from the United States, and federal officials sought your removal. It is practically inevitable that this plea would result in your deportation, exclusion from the admission, or denial of naturalization. Do you understand that?
Is your argument, okay, he's a Portuguese speaker, and this is not the easiest language to follow in the world. I mean, it could be clearer, right? I take it that's your argument, that he's not a native speaker. This formulation to a lawyer may be pretty clear, but it may not be clear to him. Right?
Yes, so I think that even if the judge had provided sterling immigration advice, it's different getting it from a judge at the plea hearing as opposed to receiving that advice from your attorney.
That's like getting to a question that I had, which is, does the case law talk at all about the timing? And it seems to me that as the very last part of the plea colloquy is quite different timing than when Mr. Barros initially made the choice to forego counsel during the entirety of any plea negotiations that would occur. Is there case law that directs us to take that into consideration?
No, there's no case law that speaks to the timing, but I think that the timing is I think a huge part of this, because it's part of the practical consideration of how these waivers of counsel are borne out in the trial courts. When a defendant waives the right to counsel, they don't know. They often waive the right to counsel, and then there are further hearings, and then ultimately the defendant makes the decision whether to plead guilty or go to trial. So it seems problematic it's sort of the invitation to constitutional error to say that a judge has to form their colloquy based on what the defendant is subsequently going to do. It's something the judge has no idea about, and the defendant may have no idea as to what they're going to do at that point. So certainly when the waiver of counsel, especially at arraignment, if the waiver of counsel occurs at that point, then the advisement has to be consistent with what this court has previously held is required. Because again, it's an open invitation for constitutional error. What if the judge gives the advisement that, say, the Supreme Court would have said that was involved in Tovar, and then, or sort of assuming that the defendant is going to plead guilty, and then the defendant doesn't plead guilty, goes to trial, then there's a huge problem there.
Well, wouldn't the judge in that case just revisit the issue appropriately? before the trial starts and revisit with the defendant? Are you sure you really want to do this?
Well, in the district court, these cases often go in front of many different judges. The judge at the arraignment was not the judge who took the plea. The judge probably, by the time the case was ready to be resolved, the judge probably would have no idea as to what the content or the substance of the initial waiver was.
I thought your client waived each time there was an appearance, right, at the arraignment, and then there was a pretrial hearing, and then there was the actually accepting of the plea hearing.
Yeah,
And each time, the issue of counsel was revisited.
yes. So, well, it was, I think, revisited twice. And at the initial arraignment, it was, I would say that's when the waivers actually, I think the court accepts that he has waived the right to counsel. And then it's,
My notes say it was the 3 times. It was arraignment, pretrial conference, and then the next day is the plea deal, where there was again a third denial of counsel.
yeah, so I guess it's sort of splitting hairs, but the first, at the arraignment, he's advised about the right to counsel, and one could call that more of a colloquy. The second time at the status hearing, I believe he's just asked, are you still representing yourself? And he says, yes. So I wouldn't call that really a colloquy.
But then the
at
third
all.
time.
And then the third time would be at the plea hearing, where he is advised that he has the right to counsel.
But if he goes to trial, the judge is going to revisit, because the judge has to give the colloquy for trial, right? That's why you're here, obviously, is the colloquy for plea. But at trial, we mandated a colloquy, correct?
Well, I'm not sure that would be required. I mean, I've reviewed district court cases where the case is about to go to trial, the defendant's representing himself, and the judge simply asks, has he signed the waiver? Is the waiver in the file? Yeah, the waiver's in the file. Okay, so he's waived counsel previously. Let's go to trial. And that's...
And that complies with Cote and Mellon? Or you're just saying the general practice?
Well, I think it would depend on the content of the colloquy when he actually waived counsel. So if when he did waive counsel, if he was advised about the dangers of self-representation, then that would be certainly adequate. But if he was not, then it wouldn't be adequate. I think it's certainly better practice and I think most trial judges would revisit the issue of the waiver when the defendant ultimately really was going to proceed to trial.
Attorney Crane, because I see your time's running out, I really want to ask you a question that I'd like you to get to, because it wasn't really briefed in either side's briefs. But you keep saying that the admonition that essentially it would be folly for you to represent yourself is something that we've previously required, and I don't know that I necessarily agree with you. But assume for the sake of argument that we do agree with you that it should be something. Why wouldn't this be a new rule? And if it's a new rule, isn't there an issue of retroactivity here? I'm not trying to catch you without being prepared for it, and if they need to ask the chief for leave to do some subsequent briefing, I would like that. But it would seem to me that this would be a new constitutionally procedural rule, and don't we normally apply that prospectively and not retroactively? So even if we were to agree with you and we say that we got this new rule and people have to go forward doing this, judges need to do this, would Mr. Barros still get the benefit of that?
Well, Your Honor, I'm thankful to say that I've never had to deal with the issue of retroactivity of a new rule or not, and I think I consider myself fortunate. It sounds like I probably will have to
Time's
address
up.
that issue.
Yeah. And that would really be helpful, and I would just refine something that our research has really taken a look at as to whether or not the procedural posture of the case is a direct appeal or is it a collateral attack. And there is some discussion about whether or not, if it is a collateral attack, whether it should be applied prospectively and retroactively in the differentiation between a direct appeal and collateral attack. And I think that is an issue that needs to be addressed that wasn't addressed in the briefing.
I'd be happy to address it in supplemental briefing.
So you can file a 16L. That's fine. Can I just ask, I think this question was already asked, but I'm not sure if it was answered. Say we agree with you, there's error here, and your client gets the benefit of that. Where's the substantial risk of a miscarriage of justice?
So the substantial risk, the standard is whether there would be a serious doubt whether the result of the proceeding would have been different. And where I see the result of the proceeding would have been different would have been, he would have had an attorney. The attorney would have advised him that there's certainly, I don't know how you exactly phrase it, but there's a risk that you're going to be deported because of this case. As he says, well, I don't want to take the quaff right here. Can we resolve this case in a way where I don't face this risk? And the attorney would say, well, maybe we could play it down to simple A and B without the domestic aspect of it. I think that's a totally reasonable way to resolve this case. The domestic aspect of it adds nothing as a practical matter for the prosecution. This is a defendant with no criminal history. I think the Commonwealth would have been willing to accept him pleading out to the same exact disposition, but to straight, simple A and B. And then, thus the result of the proceeding would have been different.
What's in the record to support that position? I agree, it sounds reasonable, but is there anything in the record that your client has made that supports that? He's being deported to Portugal, a country in which he grew up and was employed.
Well, I think the evidence indicating that immigration was something important to him was that he had just previously gone through the whole process of becoming a legal permanent resident, which is a timely, I mean, it requires a lot of time, a lot of money. You got to pay an immigration attorney to do that.
The speculative part, though, is that the DA would have dropped the domestic part of the case. I could see if your client said, well, I had a motion to suppress that I could have brought, but here there's no defense to punching your girlfriend in the face.
It's difficult to provide evidence on that aspect because I can't get in the head of the DA's office.
Right, that's the speculative part of the prejudice.
But I do think it's a reasonable disposition, especially because, again, there really is no practical benefit to the Commonwealth to having that.
Well, they don't want to be soft on domestic violence. How about that?
He still gets the same disposition, and I would argue he'd be willing to have agreed to a stiffer disposition, another 6 months of probation in exchange for dropping the A and B. I'm sorry, the domestic aspect of it. So I think he could have. That might not have been the only way, but I think there's reasonable probability that he could have negotiated an immigration-safe disposition.
Okay, thank you.
Thank you, Your Honors.
Attorney Sanchez.
Good morning. May it please the court. Alicia Sanchez for the Commonwealth. I ask that you affirm the denial of the defendant's motion to withdraw his admission to sufficient facts. I'd first like to address his letter updating the court regarding the termination of his removal proceedings. It's our position that under any scenario now, the defendant can't meet his burden to in order to obtain relief. He can no longer claim prejudice because he's no longer at risk of being deported as a result of his admission to sufficient facts. So it's also our position that it's not necessary to reach the constitutional issue, but I recognize.
So they're not pursuing deporting him? Is that?
He's no longer as of October of last year, an immigration judge determined that the offense wasn't a deportable offense, and the proceedings have been terminated. The time for appeal has passed, and so it's no longer an open issue.
Okay, but so now, if his case may be moot, but we do have a sort of a significant constitutional issue.
Yes, we do. We recognize that it's within your discretion to decide the issue. And with that, I'll turn to the issue now. The question is whether Article 12 of the Declaration of Rights requires greater protection than the Sixth Amendment regarding the validity of a waiver of counsel at a plea hearing. And we know that the Sixth Amendment under Iowa versus Tovar requires that a trial court inform the defendant that he's aware of the nature of the charges, the availability of counsel at the plea, and the
Isn't this just a good rule going forward? Because the defendant doesn't know what the defendant doesn't know. Why wouldn't we just tell them as a, you know, as a matter of our jurisprudence that in the event you have a plea, you should tell the defendant what this decision really means, so we don't have these issues popping up in the next case.
So the issue with, if it's constitutionally required, then at every hearing, no matter what the cost that the district court say, that's what is required.
Right.
But if it's not constitutionally required, then it would take valuable resources away and
Give me the valuable resources.
I'm sorry,
What are the valuable resources?
just the time in telling somebody.
Another sentence or two?
If it's another sentence or two, I think the question is, there's no doubt that that wouldn't require much time. But I think if it's another sentence or two, I think it should be a meaningful sentence or two. And there's a question of whether telling somebody that for example, you might get a better deal, or this person might be more aware of immigration, might be able to advise you of immigration law.
We don't have to necessarily get into the weeds of all that, but the judge can just say more generally, and we've got plenty of examples of other jurisdiction, even in our jurisdiction. I forget the case in early 70s, but they talk about that you'd be basically a fool for doing this, because you're going to be held to the standard of a practicing attorney. You're not going to know the procedural stuff. You're not going to know the substantive law. You don't have to get into the kind of granular detail of what you might or might not be able to do vis-a-vis representing yourself or getting a lawyer.
I think at that is most valuable at the trial stage, our case law has said, and we follow.
You have some, again, they don't know what they don't know. So they don't know if they have defenses. And then you look at the number of cases that get resolved by plea versus the number of cases that get resolved by trial. There's a huge discrepancy in
Right.
this.
So it's our position that at a plea hearing, with the same reasoning as in Iowa versus Tovar, there's a unanimous decision written by Justice Ginsburg where she determined that at a plea hearing, it is not any less important than at a trial, but at a plea hearing, the accused is the dangers of self-representation or more apparent and more obvious to the accused. So,
But isn't that exactly the opposite, honestly? Because if a person is going to be going to trial, right, they know they're going to have to examine witnesses and stand up there, and it's kind of self-evidently daunting, whereas a plea seems easy and straightforward. But, you know, a defendant may not know that in Massachusetts we have defendant cap pleas, for example.
So the defendant, here in this, just using this example, the defendant decided to exercise his correlative right to self-representation within Article 12, and he decided to proceed knowing that he was aware of the nature of the charge. He was aware of the possible punishment of 2.5 years if he violated probation, and he was aware that he had the right to an attorney.
Did he know of the defenses, the possible defenses?
He did not know the possible defenses.
Knowing in intelligence, we have
Right.
to know.
Did
So you have to
anyone?
get the police reports and then figure out, do I have an out or
Right.
not?
Yeah, he knew he had the right to have an attorney advise him on defenses, but instead he decided to take this 1-year quaff.
Because it sounds great but particularly if you don't understand the immigration consequences.
Yeah, and
So
that's a big deal.
definitely,
And I want to add one more thing.
sure.
That we can't ignore the reality that people just want to go, they want to leave. And so if it's a decision between let's plea or go to jail, they just want to plea and get it over with, and they don't really understand the full consequence of what might happen. And that's what goes on every day in our community courts. So I'm struggling to see why the Commonwealth is fighting this.
Well,
I really am. Why, what are we fighting?
If this court decides that there's there's wording that might help a defendant, and that's constitutionally required, it's our position that that is definitely within your discretion to do so. It's our position just that under the federal law, that the Sixth Amendment and Article 12 are coextensive here for certain reasons, being the way that we've interpreted the waiver of counsel at a trial. We've taken the pragmatic approach, the same as we did the same at the federal level that's taken.
We could also say, like we did in the violation of probation colloquies, that it's better practice to do this, correct? Going forward.
Say that one more time, I'm sorry.
We could also say, if it's not a Sixth Amendment right, which it probably is, but assuming that it isn't, we could say it's better practice going forward to give this colloquy, which is what we did in the violation of probation cases.
Definitely. Yes.
Counsel, you started your argument by saying that if the test for voluntary, knowing, and intelligent waiver of counsel at the plea hearing stage is upped by this case, that there would be some sort of parade of resource deprivation. Can you explain to me what you meant by that?
If a judge at every time at the district court, if a defendant is trying to plead or make an admission for sufficient facts, and he wants to proceed, and he wants to exercise his right to self-representation, his constitutional right for self-representation, and the judge needs to ask him several questions to make sure, do you understand the perils of self-representation at this plea hearing? Do you understand that you might get a better deal? Do you understand that you might not be getting the most favorable outcome? That amount of time may take away valuable resources.
So it's the time that you're concerned about.
That's just one point, really.
Well, what else is there?
What else is there is there's the confusion, as noted in Iowa versus Tovar, the possible confusion of somebody who doesn't have a viable defense and somebody who...
So they would be confused by the fact that the attorney could help them?
Yes, and so that would result in impeding...
I'm sorry, can you put a finer point on that? What is the confusion by telling somebody that an attorney might help you?
So there's the confusion of, like in this case, this person, in this case, there was likely no chance that there was going to be any lesser charge from the Commonwealth, that they would agree on that.
Why is that?
Yeah, can you explain?
Because there was the evidence of the police observations, and there was medical records about the injuries.
Yeah, but you're also not addressing the issue that it's one less element that the Commonwealth has to prove at trial. So there is some benefit to the Commonwealth reducing it to simple A and B.
Well, here, we didn't want, they wouldn't, I'm sorry, I feel like I'm not answering your question, but I will return to it. Here, in the end, we wanted to pursue an A and B on a family member. The defendant was required to partake in the Barros program, which is a good thing.
Which he still could under the A and B. Still be a condition of probation.
If I could go back to
It's still Justice Wendland's question, because you're saying we wouldn't do that, and I'm just saying, why wouldn't you do that when there's the issue of all the same probationary conditions could be implemented, and you'd have one less element that you'd have to prove at trial?
Yeah. It's my understanding that a lesser charge would not have been
Forthcoming.
Yes.
Can I ask one other? Could you address the amicus? The amicus CPCSS, not only that you instruct on sort of the difficulties of self-representation, but have a particular instruction colloquy on immigration consequences. You want to address that? Because they're asking for something more than Mr. Crane is asking.
So they're asking that the judge state outright
That you need counsel for you better talk to an immigration lawyer because this stuff is really hard.
Yeah, yeah. First, I just like to point out that wasn't briefed, but
Briefed by the amicus.
amicus, yes, by the amicus. But I think they're asking for something that would require the judge to kind of take an advocacy role where a defendant is kind of put in a position where he's being nudged between two constitutional rights, one to self-representation and the other to counsel. And here they're in a position where they choose to exercise their the right to self-representation and are ultimately informed by the judge of this risk of deportation. So I don't think it's necessary.
Can I ask one other question? And unlike Justice George, who sat in one of these district courts,
Yeah.
so what, I mean, you're talking about the burden, but what percentage, do we have any sense of the percentage of unrepresented people doing pleas? Do we have any feel for that number?
I don't know the percentage, but I know it's from what I've been told, it's a significant number. But I would just also like to briefly point out regarding the questions on whether he was a native speaker or not. The judge ensured that he asked him at the arraignment, do you understand English? And he said, yes, I have no problem understanding English.
I'll be honest, I read what Justice George has read. It's not the easiest thing to follow, and I'm a native speaker, you know. If it is a second language, that's going to be somewhat difficult to absorb, isn't it? Especially you're in court, you're under pressure. It's not the easiest thing to follow.
I understand it might not be difficult, but it might be difficult to understand with English being your second language. But here the judge, what was before him was somebody who was saying he completely understood. And he seemed to have no problem going through the colloquy. All of his answers were unequivocally yes. And the warning was also provided on the tender.
Attorney Sanchez, I would ask the same question, even in light of what you advised us about the fact that perhaps Mr. Barros is no longer facing the issue of deportation. Is there still the issue here about whether or not if we do anything, whether there's any retroactive or prospective issue? Is there still that issue here for Mr. Barros?
For Mr. Barros,
I don't mean to, again, I'm going to say the same thing as Mr. Crane, that leave to the chief to think about this and follow up would be helpful if you think that it is, but it looked like there is.
So if this court were to decide to make a new rule, there may be a chance for this to apply to Mr. Barros. I know under Sylvain 1, it was determined that whether something's a new rule or not is dictated by precedent. And there's two exceptions to that. And one exception is whether a new rule should be applied retroactively if it requires the observance of those procedures that are implicit in the concept of order liberty under Teague. So there is a possibility that it would be retroactive, and it would result in a number of petitions or, similar motions.
Okay, thank you.
Okay, so if you want to respond, assuming Attorney Crane does submit something on retroactivity, you please do respond.
Yes, I will.
Okay.